It's nice to see everyone in the hall and those who are online. It's just a truly proud moment today to be in front of the community, because it's been such a long time since our members and other nations have been fighting for this. I want to give thanks to Justice Laforme that made his way to Dokis and doing presentation, to Duke, who is going to be speaking and giving you more information, and Dean for being gracefully coming to Dokis. There's one person that I would like to, I know sometimes he says in his opening that he may be from Nipissing, but truly in our heart he's always our member, and that's Mike Restool. And I think for us, everyone here owes him a great gratitude for actually putting his name forward, to actually have all those long hours that he put in, that he had to listen to us chiefs talk too much, to actually go and part of the negotiation. And I think it's just an honor that his name is put on this case. This case is such dear to all our nations, and I just want to maybe everybody lift their hands and clap for Mike for this. And before we start, I think throughout all those years and how much of our litigation team has put forward all those hours, there was a change in our litigation team, and for Corbière and Agalbo, who are putting such a great effort forward, who are fighting the fights for us, and sometimes that we're not allowed to be in those discussions, but they speak on our behalf. And I know for Dean and Duke, our representatives who are a true heart for us, and I think there's nothing that they wouldn't do for our communities, not alone their communities, but everyone that we belong to. I wanted to say thank you. I know I saw Peter Reckle, he's in the back, so Chimigwech also for the litigation and litigation committee, and those who work tirelessly for us, to whether it's coordination, getting us an advice, producing wonderful information on the websites, the pamphlets, to make sure that we're informed. I know this year the gathering will be held in conjunction with Garden River and Batchewana again, and we'll be heading to where that treaty was signed in 1850, back in September 9th. So it's an honor to return to their treaty lands. It's something that I do believe that it's been, we're the 17th community that they've been hosting this, and the Mizhinewe was sanctioned to do that, to make sure that it's not just coming from Chief and Council, to make sure that the whole history of what that court case has been, all those timelines, and what every time the Chief or a Council has been there on the true goal was truly fighting for our communities, and what was rightfully supposed to happen on that September 9th day. What those chiefs at that time truly believed what that treaty meant. And it took us so long because we were not even allowed to fight a court case. We were not even allowed to bring grievances. And I know even our chief, not too long after the treaty, was writing and saying, you are not honoring that treaty. You are not doing what you were supposed to do. So I think the first grievance was September 10th, 1950, that the Crown was not doing what they were supposed to do. So those who know, I can stand up here all day long, so I won't do that because we have special guests who can explain a lot more than me. So I will turn the mic over to Duke and do an introduction and start off this meeting. But again, I just want to thank everyone that is online and in here to listen. And this is a kickoff meeting. Nothing has been decided, nothing has been discussed. This is our first meeting to move forward. So miigwech for that.
I think your Gima took my speaking notes. He explained it all already. No, I'm kidding. There's what we're going to be doing here tonight. I'm very honored to be here on behalf of the Litigation Management Committee as a representative of the Robinson-Huron Treaty Litigation Fund. And we do have some members here. You already know of Zhushk, Mike Restool, who's our chairperson, and Peter Reckle, who's the vice chair. They've been doing a lot of the work, and obviously Dean Sayers and myself have been doing the faces, I guess, of the Robinson Huron Treaty Litigation Fund and speaking on behalf of all the chiefs and yourselves and going into the meetings with the Crown officials. So we're gonna explain a little bit about the history, but we're gonna first get into the presentation here and introduction from Justice Harry Laforme, who's been appointed as Mizhinewe to be able to take in your opinions and your thoughts in helping him develop a report that's going to assist the leadership in developing a plan for the funds that are coming into the communities, because it is a significant amount of money, and the chiefs wanted to ensure that there is some recommendations coming from an independent party that had heard from a lot of the community members. So we're going to get right into the presentation from Mizhinewe, and then I will provide an overview of the actual case, negotiations, and I'll talk a little bit about what the court has said on the annuity. And then our legal representative here, Daniel McCoy, he will be speaking about the actual settlement agreement and the trust indenture, as well as providing some timelines. So I do want to thank everyone that is on Zoom, and they will have an opportunity to ask questions in the Zoom, and there is a legal personnel who is answering questions for them. But we will have an opportunity after the presentations and prior to the break for you to ask some questions. So we're going to go over into presentation. So, Harry? Stand up. It's up
to you. Hello, everyone. Anine. First, I want to give thanks to the elder who opened us with a prayer. That's always a good thing when we start the right way. I want to say Anine to all of you and those on Zoom, and I hope that this is an information and a time for learning for everybody. I want to bring greetings from my own First Nation, which is the Mississaugas of the Credit. They know about your settlement, and they wish you all the best in your implementation of it. And so I bring greetings from them. Miigwech for allowing me into your community to speak to you about my responsibilities and duties as Mizhinewe. That question gets asked quite often about what is a Mizhinewe, and it's a name that's gotten out of use, and it's an Anishinaabe name, and it was a word for the person who was described sometimes as a near chief, and that person would be responsible for visiting one chief and the next if there were big gatherings of our people, and they would go from one chief and deliver messages to another chief and to another one and give recommendations on the way and give that information as they got back. So it seemed to fit with the responsibilities that the Litigation Management Committee provided me with. So that's what I'm going to try to do. To start, I'd like to begin by telling you a little bit about myself and how I got here. And I think that's important because I think it's important for you people to know who is doing what for you, who's doing a responsibility and what their responsibilities are and who's doing that job. And I think I'd like to know that when I'm finished that you'll have confidence in me that I'm going to be doing this the right way and doing good for you. So I was born and raised on my own First Nation, Mississaugas of the Credit, on the reserve. This was back in the days when the Indian agent ran everything, as you may know, and government responsibility for us, as they said, was almost complete, almost total. And I remember those days all too well as a young man with visiting my grandfather and having all those lessons taught to me, and they weren't lessons that were necessarily good ones. I began my journey as an Indigenous man pursuing our rightful place, or what I thought was our rightful place in Canada, with an organization called the Association of Iroquois and Allied Indians. I was its first executive director in the early 70s. From there, I went to law school in 1974, and I was amongst the first wave of Indigenous people that went off to law school in those days, because at the time, there were 4 Indigenous lawyers in the entire country. So there was a place for us and a need for that kind of education and that kind of pursuit, if you will, when I graduated. And so when I graduated, I was in the practice of, and maybe one of the first lawyers that practiced exclusively in the area of Indigenous rights. They called them native rights at the time, as you'll recall. Some of you may. And I specialized in those areas of Indigenous law and, again, searching for our proper place and our equal place in Canada. And some of the Robinson Huron First Nations were actually my first clients, because at the time, Indigenous lawyers were thought of as not the real thing. They thought we had not earned our right to practice law, but that was given to us, and we were nothing more than token members of law school, and were token members of the legal profession. And so some of the Robinson Huron First Nations didn't agree with them, and they hired me, and that was the beginning of this most beautiful journey that I could possibly think of that I've been on. Then came my appointment in the early 90s as the chair of the Indian Claims Commission. And during this time, I co-chaired the Chiefs Committee on Aboriginal Land Claims. That was all across the country. And I chaired that with Chief Manny Jules of the Kamloops First Nation. He's now chair of the Indigenous Tax, whatever they call it, body. And this in turn led to we ended up with a report, and our report called for an independent process to assessing land claims. And that was going to be part of what we hoped would be, because up until that point, you may recall, Canada was the judge and the jury and sometimes executioner of our land claims. They decided when they were proper claims. They decided when they could be negotiated. So we thought there was an independent body needed to be put in place. So indeed, the Prime Minister at the time, Brian Mulroney, asked me if I would start this commission, and would I be the first chair of this commission. So I certainly said yes, I would, and we started it. And it continues until this day. It's had many iterations, but the most significant was it became an actual legal body. So today, there is now an Indian Claims Tribunal, and it grew out of that establishment of that first Indian Claims Commission that we had way back when. Then in 1994, from that position, I was asked by the Liberal government of the time if I would become a judge on the Superior Court of Justice. And I was excited by that prospect, and I said yes. And I was one of three judges, Indigenous judges in all of Canada at that time. And so that was a kind of a first, and it was a daunting task. Like all those positions when you're into things like that are new and that are important like that, there's a sense of loneliness that sets in because you can't talk to anybody. There's nobody to talk to about where you came from, what you did, how you grew up, because everybody around you grew up differently than you did. But nevertheless, I survived for 10 years, and I think quite well. In 2004, in fact, the then Liberal government appointed me as the first Indigenous person ever to sit on an appellate court in Canada. And that has been a source of pride, and that was one that I was very proud to serve. Again, it was a very lonely position because, once again, I was surrounded by people who did not know me or where I came from or what my life was like, and I didn't know their lives and where they came from and what their lives were like. So it's a fairly lonely existence, and I did that for 14 years, and I was the only one that was on that court, only Indigenous person for 15 years on a court where I didn't have any company at all and that was related to me. I retired in 2018, and I thought at the time that I wanted to be a voice in what was happening, what took place over the last 25 years of my life as a judge. Many things had happened in the area of Indigenous law, and I wanted to be a voice in that. I wanted to have a voice, and I wanted to assert my opinions in any way that I could. So I joined a law firm that had specialized in that kind of litigation. It was Indigenous, and it was representing First Nations exclusively. And as luck would have it, I became lead counsel on the class action that First Nations had against the Government of Canada for clean water, for the negligence of Canada for not providing clean water on First Nations. So I was the lead counsel in that class action, which ultimately settled for about $8 million, and it's ongoing. Its implementation is in process right now. Then in the year 2020, I was asked by the Justice Minister if I would conduct consultations, if you will, on an independent process to address the issue of wrongful convictions. And he asked me because he knew I was very interested in the amount of Indigenous people that were incarcerated in our prisons. It was, to me, astounding that the numbers were as they were, and I thought this was a way to have a voice in some small way of addressing that. So we tabled our report in 2021. I think it was on my birthday, in fact, October 31, that we tabled that report. Now that has gone through 2 readings as a bill and is now ready to become law in one form or another. And I hope to have further say in that matter and how that's discussed. And I would like to make sure that there's Aboriginal and Indigenous appointments to that commission. So that's it. I'm here. I was then appointed Mizhinewe, and I had to take that on because it involved Robinson Huron First Nations, and it was they're friends of mine, and I know a lot of them. I go to every community, and everyone I've been to, I got a chance to meet friends that I hadn't seen in a long, long time, and it's been wonderful. And I hope this gives you some idea of who I am, and I hope it gives you confidence that when you make recommendations to me or suggestions to me about what we should do with compensation, that I'll do my best to represent you and to put forward what you believe and what I believe is the correct way to do this. How am I supposed to do it, and what am I supposed to do? Well, my duties require that I collaborate with Litigation Management Committee, but at the same time, I'm independent. That means I think for myself and do for myself. I'm to engage in information sessions, which I'm doing today, to ensure that the beneficiaries of the Robinson-Huron Treaty are aware of several things. One, the trust indenture. That's the instrument that basically got us here, and you'll hear more about that. from legal counsel. The settlement agreement, which is where we ended up, as you might say, the litigation ended up in. And I think it's important to say, for you to all remember, that this is just for past compensation of the Robinson-Huron Treaty. That means from 1850 to whatever 173 years later, there is a settlement of that past amount. The future's yet to be decided. How we go forward is yet to be decided. That's either to be litigated or negotiated as well. But this piece is for the past. And then after that, we're going to hear some discussion about the compensation disbursement agreement. It was an agreement that was agreed to and put in place by Robinson-Huron chiefs and councils in 2012. And that was, if you think about it, was before anybody knew we were going to win the case, or you were going to win the case. And it was before anybody knew there was going to be any money. So when I talk about the old chiefs in 1850 being visionaries, you can also go to the future and talk about these chiefs were visionaries in my view. Today, on the information side, we're going to hear from Duke Pelletier. And as I tell everybody, I love to hear from Duke because I learn something new every time. Dan McCoy is going to be giving us the talk about the indenture, the settlement agreement for past compensation. And then Ryan McLeod, who will be on virtual, and he'll be talking about the compensation disbursement agreement and giving you some idea about how that will work. Thereafter, it will be my job to listen to you and other members of your community about your thoughts on the settlement agreement, what recommendations you have about how this settlement agreement should work. In particular, I want to hear about your community or collective, what they call collective needs, should be balanced against individual or per capita needs. I hope that when you're thinking about this and making recommendations, or what recommendations you would make, that you keep in mind that the Robinson-Huron Treaty was all about. And it was about chiefs back in 1850. Again, I'll say they were true visionaries. In signing their treaty, their intention was to provide their people with a way to prosper in an ever-changing Canada that would see their traditional means of livelihood changing along with it. They were concerned for the future of their people and wanted them to be able to share in the monies made through the resources of their territory by the Crown. They were thinking about the future generations of Anishinaabe people and wanted to provide for them. This vision, I think and I believe, was accepted by our Canadian courts. In the trial decision, for example, the judge held that the treaty provided that the original amount of 600 pounds, that was about $2,400 at the time, was the collective. That was the overall amount that was to be paid, and it was the amount that was to be increased annually if the net revenues from the territory allowed for it. That means the net revenues of the government, not independent contractors who came in and profited from that land, but the province itself, the net revenues that they made from the territory, like in stumpage fees or licensing fees or what have you. Anyways, the amount of 1 pound, which was originally distributed, it came out of the collective. It was all part of the collective, and it was given to the individuals, but it was never to change. It was always supposed to remain at 1 pound. The court found that Ontario, or especially, chose to interpret the treaty the wrong way almost immediately. They chose to disregard the chiefs and distribute the 1 pound to individuals themselves. This was obviously less expensive than addressing the 600 pound augmentation or increase that was supposed to occur annually. The practice of paying $4 that they did to individual treaty holders, as you know, continues to this day. Your legal team, as I mentioned, will be addressing that going forward in further litigation, in future litigation, or in future negotiations. And that is going to be a formula on how to augment that annuity. I should add that this trial was upheld by the Court of Appeal for Ontario, and in turn, we're here now with the settlement agreement. As you'll see from the compensation disbursement agreement, when Ryan has his opportunity, it provides for a 10% of the settlement amount, and that is for collective purposes exclusively. That is for the benefit of all 21 Robinson-Huron First Nations. And when there's going to be breakout groups, and when that happens, I'm going to be asking you to think about the purposes, what you think these funds should be used for. For example, should it be used for future litigation? That's all of us have, as First Nations. We have ongoing litigation about boundaries and things like that. Should it be about rebuilding a united Anishinaabe government, for example? Economic development projects, wellness benefits. My First Nation delivers wellness benefits to every member of the community each year for proceeds from our original land claim settlement about 25 or 30 years ago. The retirement benefits, maybe guaranteed income supplements, that kind of thing. But your thoughts and recommendations are very important to this process, so please participate and give it some thought. After the information discussions and consultations with individual treaty rights holders, I will be preparing a report for the Litigation Management Committee that will include your views, your suggestions, and your recommendations. My report will also include my recommendations on how the compensation for the past breach of treaty should be distributed. And my recommendations will be made up of what you tell me. Whether these recommendations are adopted will be up to the First Nation themselves. They will only be my recommendations. Finally, I want you to know this session is only the first of several more discussions I will want to have with you. And you're going to go away. You'll be thinking about what happened here today. You'll be thinking about what your neighbors said. You'll be thinking about what happened at these various discussions. And then you're going to have more thoughts. You can either give me them in some other session, or you can communicate directly with me, or you can contact websites and put those recommendations and suggestions forward, and I'll be happy to receive them. Now, that's it for me. I'm sure you've had enough and you want to hear more about what's happening here. So our task and mine is going to be very much like yours. We're going to sit, we're going to listen, and we're going to learn, and we're going to see how we got here. So I want to thank you for your attention, and miigwech to everyone.
Okay, miigwech Harry. And can you get my presentation up on the screen there, Matt? Good. Okay, you can go to the next one. Next slide. So miigwech kinawea, nigan wasaganaba geni dishnakas kwando dem. Kibeneshi gemanatamak menage we kwemkong binjaba. Mi woda geni gajanagmego manda winatamagia manda wawindamadwin. So good evening, everyone. I want to thank you for coming out tonight. My name is Duke Pelche, and I'm a trustee that's been appointed by Wikwemkong's council and been in that capacity since 2010 when the trust was established. And I've also taken on a couple roles from the trust itself, one of them being the litigation management committee member, and also one of the appointed spokespersons or co-spokesperson, along with Dean Sayers from Botswana. And I want to thank you and all those on Zoom for allowing us to bring this information to you. So I'm going to go, part of the information that I'm going to share with you is just a brief history of the litigation itself, the court case. I'm going to share a little bit about the negotiations that have taken place to get us to the point of a $10 billion settlement. And I'm going to share some information about what the court has said about its interpretation of the actual annuity clause itself. And as the trust has been directed by the elders and knowledge keepers, prior to establishing or taking any activities against the Crown, the ceremony was important to the leadership. So ceremony has been used at every point, right from the beginning, including sweat lodge, including pipe ceremonies, having elders and knowledge keepers advising every single process along the way, including making plans for the Robinson-Huron Treaty gathering and having a pipe ceremony on September the 9th. So all of those, it's going to continue, and we need to acknowledge that guidance from our elders and knowledge keepers. One of the other further things about the litigation is that one of the directives to the legal team was that they wanted to ensure that Mizhinewe law and the perspectives of our elders were at the forefront of the legal proceedings. They wanted to ensure that our views were parallel or on equal footing with the Canadian legal system. Little delay on my finger here. So one of the things that the chiefs and leadership, Gema Duquette here mentioned September the 10th, 1850, when grievances started. So our leadership have put forward many letters, had many meetings with Crown officials for many, many years. And it took a long time for our leadership to, after a few false starts in the 80s and 70s, 80s through the 90s, and Mike was involved in the 90s, and I think that's when he first started, and Peter Reckley. And they were, one of the things that the chiefs had realized is that they did need to organize themselves in order to bring this case against the Crown. So one of the things that they wanted to do was they put out a terms of reference identifying that they required legal representation to bring this case before the courts. They had tried previously, however, they at a few different times they ran out of resources to be able to continue bringing this case before the court. So what they asked as part of this terms of reference is for a legal firm to bring forward a plan that included how to bring the case into the court, but more importantly, how to actually win the case against the Crown in the courts. So in 2007, the leadership, they retained the legal firm of Nawagabo Corbier, which is David Nawagabo, Diane Corbier, and Roger Jones. And through it, they sought out their advice on the best way to bring this claim to win against the Crown, and including how to organize the Robinson-Huron Treaty together as a collective entity. So part of their advice was to create the Robinson-Huron Treaty Litigation Fund as a trust vehicle to launch this claim, and to launch it as a representative action. So as part of the representative action, 6 individuals were named by each of the 21 First Nations. So the 6 individuals were Mike Restuel, Peter Recollet, Dean Sayers, Patsy Corbier from Ondakamnakaning, Roger Daybush from Mississauga, and myself from Quemacong. So each of us were authorized by not only each of the 21 First Nations, but also authorized by court order to bring this claim on behalf of all the beneficiaries of this treaty. So as part of getting set up to bring this case forward, one of the things that in August of 2012, the chiefs had met in ceremony again, and part of that discussion in August was to approve of the compensation disbursement agreement that was mentioned by Harry earlier. And that set the stage for the authorization to legal counsel to bring this matter before the court. So one of the things that has to happen if you're going to be taking the Crown to court or sue them, you do have to provide notice to them. And there's a notification period that exists in their own legislation. So in 2012, notice was served upon Ontario and Canada. It was a hand-delivered letter to the back door of Queen's Park, because we weren't allowed in the front door at the time. But you may see today we're allowed in the front door nowadays. So legal team was authorized to prepare the notice. Notice was delivered, and that set the stage for bringing this matter against the Crown. So one of the other things that was authorized at the same time, and the chiefs, they wanted to ensure that the door remained opened to allow for a negotiation to also happen should the Crown choose to do so. So what they set forward was a two-stage process. One, the court, but also leaving the door open to negotiate. And they wanted to make sure that that option was left open, because they knew renewing the treaty was best left, renewing and recognizing the treaty was best left to a negotiating table directly with the Crown, as opposed to inside the court system. And they wanted to make sure that these negotiations were consistent with Mizhinewe laws. However, the offer to negotiate at the time wasn't accepted, and the Crowns weren't interested in any negotiations, so there was no choice but to launch the case in the court. So in 2014, authorization was given to launch the statement of claim against the Crown into the Ontario Superior Court. As part of the court process, the judge that was appointed was based out of Sudbury, and her name was her name is Justice Hennessy. And through discussions with the Robinson-Huron Treaty Legal Counsel and the Crown legal representatives, there was an agreement that in order to allow this case to proceed as quickly as possible through the justice system, they agreed to split the case into 3 separate stages. And this was done because treaty-related cases across Canada typically take 20 to 40 years to get resolved. So the chiefs knew that. Legal representatives had notified them of that, of how long it takes for cases to proceed through the court systems, as well as how much it costs to take a case to that kind of level. And these kind of treaty-related cases usually take that long and cost millions and millions and millions, and probably more millions of dollars. So stage 1, what they decided was going to deal specifically with the annuity augmentation or increase clause, and whether or not the court would be able to enforce that through its interpretation. Stage 2 was going to deal with technical defenses that Ontario was putting forward, and that was for limitations and Crown immunity. These two defenses, one, the limitations. In Ontario's legislation, what it says is that you have a 2-year window or a 2-year time frame to bring a case against the Crown. So what they were saying was that because the last increase took place in 1874, we should have brought this case into the courts in 1876. But as you know, we weren't allowed to have lawyers until 1951. And the other part on their immunity, they had said that this case was, or this matter was already dealt with in the early 1900s in the court in England, where Canada and Ontario were fighting about who was going to pay the annuity. But however, we were never represented in those hearings ourselves. And the stage 3 was going to deal with all the remaining issues, including how much compensation is owed to the Anishinaabe and how much each of the crowns was going to pay of that amount. So stage 1, opening statements to the case were heard in 2017, together with the oral evidence and testimony from many of our elders that were requested to participate in the case. And through the strength of the legal team's presentations, on December 21st of 2018, Justice Hennessy released her decision on stage 1, highlighting a major win for the Robinson-Huron Treaty Anishinaabe. In it, she said that the annuity augmentation promise was a matter that the court was going to make a ruling upon and provide interpretation on. That's just that word up there, just was not even on there anymore. Oh yeah, justiciable. It's another way of saying it. So what she said is that the Crown didn't have any discretion on whether or not to increase the annuity. She said that they were supposed to increase the annuity whenever there was a profit from the territory developments. And she also emphasized the importance of Anishinaabe law and that it was on equal footing with the common law. And it needed to be considered when interpreting the treaty annuity clause. And she also ruled that the annuity was a collective annuity. And you can read this actual decision. It is a longer read. It's not necessarily, you don't need to be a lawyer to read it, but it is available on the Ontario Superior Court of Justice website. Many of you are very familiar with the family name of Restoule in this community, so just type in Restoule and you'll see the decision pop up. And it's got a wealth of history of not only this case, but of the treaty and our people. So it's actually a pretty good read. I think, Harry, you've read it 3 times now? But I would encourage you to read it. It'll give you a good understanding of the actual case and what was decided by the court. And part of it, in paragraph 463 of this decision, Justice Hennessy said that the parties did not intend to limit increases to the annuities to $4 per person. The best interpretation of the parties' common intention, the one that best reconciles their interests, is that the Crown promised to increase the collective annuities without a limit in circumstances where the territory produces an amount as would enable the government to do so without incurring a loss. I find that the treaty promise contained in both the Robinson-Huron Treaty and Superior Treaty is a treaty right protected by the Constitution. In the very next paragraph, she says that the common intention was that the reference to £1 in the augmentation clause is a limit only on the amount that may be distributed to individuals. And this amount is a portion of the collective lump sum annuity payable to the chiefs and their tribes. And in stage 2, a couple of years after her stage 1 decision, she released the stage 2 decision. In it, she said that Ontario's legal defenses on limitations and immunity were not valid. So another big win for the Robinson-Huron Treaty. And because nobody likes losing, and when you go to court, you have an option to appeal, and Ontario elected to appeal to the Ontario court. Canada itself agreed with the decision. They chose not to fight it. But Ontario, they went to the Ontario Court of Appeal, asked for a hearing, and what the Court of Appeal said was that they agreed with Justice Hennessy's interpretation of the annuity clause. And they also agreed with her stage 2 decision completely. So, because Ontario doesn't like losing, they chose to, again, appeal to the Supreme Court. So the Robinson-Huron Treaty legal representatives are currently, have made submissions to the Supreme Court in order to ensure that there's no impact to the future negotiations for increasing the $4 amount for all of the Robinson-Huron Treaty beneficiaries. So we anticipate that we will win again, but you never know in court. And that hearing is going to be taking place in November. Stage 3 itself was supposed to begin in January of this past year, a few months ago, but however the leadership have instructed legal counsel and the trustees to suspend stage 3 in favor of negotiations with Canada and Ontario. And they did this because talks were moving along. There was indications from both Canada and Ontario that they were getting serious about having talks. But we also know that the courts probably had a hand in that they've lost every single round so far. But finally, in the spring of 2022, Canada and Ontario received a mandate from their own cabinets to begin a negotiation process to address the annuity case. And forming the negotiating team since that time has been the Litigation Management Committee and members of the legal team in order to represent the Robinson-Huron Treaty. And on December the 5th of 2022, yeah, too many machines, yeah. But on December 5th of 2022, the leadership met with Minister Mark Miller, representing Canada, as well as Minister Greg Rickford, and met in Ottawa in ceremony with them. And through this meeting, there was a commitment by all the parties that they wished to find a negotiated resolution outside of court and begin focusing their efforts on finding that resolution. And in fact, this meeting that was held in December was actually the first time since 1850 that the Crown met with the Robinson-Huron Treaty leadership. So it was a pretty significant meeting that took place, and that sent a very clear signal that they were serious about sitting down and addressing this case, this case outside of the court. So discussions took place over the next several months until we got to a point on June the 17th where we announced that there's an agreement for a $10 billion settlement for past compensation. And make no mistake, we did ask for more. We tried, we pushed. And I guess I can add a little bit to that, is that one of the factors that leadership considered was the timelines. Had we pursued to try and get more, we probably would have had to stay in the court system. So we were looking at probably adding 10, 15 years to that timeline. And typically in these treaty-related kind of cases, the courts may not even provide a number. They would say, go back and negotiate. They'd have court-supervised negotiations. So that was one of the factors to arrive at the settlement that we're currently at, was timing of it also, because we know that many elders were asking for this to get resolved, and they wanted to see some benefit, and it was one of the ways to make some changes within our communities with this settlement. So further to the court and Justice Hennessy's decision, she talked about the actual interpretation of the annuity itself. And what she determined was it was a collective annuity. And in paragraph 371, she said the Anishinaabe had an interest in taking steps to ensure the continuance of their collective well-being. They may have wanted at least some per capita payments, but they would have placed the interest of the collectivity at the forefront. The Anishinaabe had an interest in ensuring that the manner that their annuities would be distributed would not be done in a way that risked the loss of the value of the annuity. The Anishinaabe had an interest to secure benefits that would embrace and fulfill Chief Shingawakonsa's vision of a prosperous Anishinaabe nation. And through the oral evidence and the historical written reports, we do know that our ancestors that participated in the Treaty Council at Balting in 1850, we know that they were thinking about the collective, and we know that they were thinking about a brighter future for our people. We know that they also had a vision that to enter into this treaty, not just for individual prosperity, but also for the prosperity of their communities, as well as the nation. And as Harry pointed out in his presentation, they did this because the world was changing around them. In Justice Hennessy's Stage 1 decision, she also, when she found that the annuity was a collective annuity, she confirmed distributions could be made to individuals from this collective annuity. With this settlement, we need to carefully consider what the proper distribution should be so individuals can prosper, and what is the proper share to be held at the community level for all of our benefit. We've heard through a lot of the breakout sessions a number of views and opinions, and Harry is collecting those as part of these sessions, these information sessions. As I've said earlier, the current compensation agreement is for past annuities from 1850 to the present. This is compensation that should have been paid to the nations and our ancestors many years ago, and many of those people we know are no longer with us. And further, Justice Hennessy heard some evidence, and she referred directly to it, that the annuity was paid to the chiefs of each community in goods, and it was up to the chief to distribute those goods within their community in the very first years after the treaty. In paragraph 290 of her decision, she says, from 1851 to 1854, the treaty annuity was paid out in goods to each band. No individual cash payments were made. However, starting in 1855, as a result of a number of factors, the Crown began paying the annuity to individuals in money. So after sharing a little bit of that information, their leadership have been really clear with, as well as the trustees, that there will be amounts shared or distributed to individuals. But part of this process by appointing Mizhinewe is that leadership wanted to strike a balance between individual and community needs. And this is the purpose of having Mizhinewe lead these information sessions and getting your viewpoints on how to prepare his recommendations to be considered. And part of this, the leadership also wanted to have some guidance on how to take a uniform approach to distributions to individuals throughout the territory or throughout each of their communities. So with that, I want to say miigwech for listening to me provide an overview, and I'll hand it over to our legal representative, Daniel McCoy, who will take you through some of the details of the settlement agreement and the trust document, and give you some of the timelines, because you're very interested in the timelines.
Miigwech Duke, and so while they put up my presentation onto the screen, I can start by introducing myself. My name is Daniel McCoy, and I'm a member of Batchewana First Nation and a beneficiary of the Robinson-Huron Treaty. I'm also an associate lawyer at Nawagabo Corbiere and a member of the legal team. And so before I get into the formal agenda, I think it's important to recognize the other members of the legal team who play a very important part in this file. So Duke mentioned in 2007, the legal team was retained, and it's led by Dave Nawagabo and Diane Corbiere from Nawagabo Corbiere, the firm that I work at, as well as Roger Jones. There's also 2 lawyers who were retained as principal members of the legal team from British Columbia, one of which has since passed on to the spirit world, and then another 2 lawyers from Saskatchewan. And so this team makes up the core principal lawyers on the legal team, and underneath them they have different associates and juniors that work on the file, and I'm just one of those individuals, so I play a small part on the team. So if we can go to next slide, my agenda. So I'll start by talking about the trust indenture and compensation disbursement agreement. I'll then go into portions of the settlement agreement, and finally a timeline on the final settlement. Before we start, though, I will say that all of the content here is settlement privileged and confidential. And so we're able to share information with you as community members and beneficiaries of the settlement agreement. However, all of this information is still confidential in terms of the general public. And I know it's been difficult that we haven't been able to share a lot of information about the negotiations as they've progressed, and that's of course because it's all subject to settlement privilege, and we're now able to start sharing information with you about the negotiation process. And so we want to share all of the information that we can. We're going to share it with you. And I know we've been having some issues with the projector here in the room, and I think I saw some issues on the Zoom. All of the presentations today, as well as a copy of the Zoom recording or the recording in the room, are all going to be posted on a members-only portal. I noticed that you have one here, and so we'll be able to share that information so that it can be posted and you can access it and look at it later and reflect on all of the material. It is a lot of information that we're sharing with you, and so you'll be able to look back at the presentations, rewatch the recording. We'll also be able to share additional information as the process goes along, including Mizhinewe's report when those are finally ready. So stay tuned for when we're able to send that. Hopefully we can get that done quickly. It does take some time to get the recording and everything uploaded so that we can share it, but we do want to do that as soon as we can, and like I said, share all of the information that we can with you. So if we go to the next slide, I'll start on the trust indenture and compensation disbursement agreement. So on August 23rd, 2010, the chiefs of the 21 First Nations established the Robinson-Huron Treaty Litigation Fund. And that is what we refer to when we talk about the trust. And the purpose of that was to create a stable vehicle to pursue the litigation and or negotiations for the annuity claim on behalf of all of the citizens who currently receive or are entitled to receive annuities under the Robinson-Huron Treaty of 1850. And this includes the past compensation component and the go-forward future implementation of the augmentation promise. And so the purpose and the mandate of the trust is they'll act as a legal vehicle to receive money from First Nations to fund the claim and instruct the legal team in the litigation and negotiations. And then they will also act as a vehicle to receive the compensation and then distribute that compensation in accordance with the compensation disbursement agreement, which I'll touch on briefly, but Ryan will cover in much more detail after my presentation is done. So next slide. Settlement of the past compensation won't end the trust. We do have to complete the go-forward negotiations. And so we had litigation to pursue past compensation and go forward negotiations or the future implementation of the treaty augmentation promise. That go-forward work hasn't started, and it won't start until we've completed this past compensation phase. And so we haven't started any negotiations with Canada or Ontario about the future annuities, and we won't start that until after we're all done. Settlement of past compensation decision-making according to the trust. So when it comes to approving the settlement agreement, we will do that in accordance with the decision-making process that's set out in the trust indenture. And that approval process is the trustees would vote in favor of the settlement agreement, or not in favor, but hopefully everyone is in favor of it. And 70% of trustees voting in favor is what is required to approve the settlement agreement. This decision-making process in the trust has been used for all of our decisions, and we've complied with it all along. And so including authorizing the negotiators to initial the agreement in principle, which was done on June the 16th, 2023. So we'll go to the next slide on the compensation disbursement agreement. On August 8th, 2012, a compensation disbursement agreement was presented to the chiefs and trustees, and 100% of the chiefs and trustees approved the compensation disbursement agreement. All that was required was a 60% approval on the compensation disbursement agreement, but we had 100% approval by chiefs and trustees. We also received band council resolutions from all 21 First Nations approving the compensation disbursement agreement. So next slide. This is what we call the waterfall document, and Ryan will go over this in a lot more detail, but this is a visual representation of the compensation disbursement agreement. And I know it's hard to read, but the compensation disbursement agreement sets out how compensation would flow to communities, and then communities would ultimately have the decision as to what type of distributions would be made to individuals. So the compensation disbursement agreement only covers how money flows to the community level from the trust. And there's 3 priority payment areas. The first is to cover the costs that the trust has incurred in terms of pursuing the negotiations or litigation, as well as reimbursing all of the First Nations for the contributions, the cash contributions that they've made. They would also receive interest on those contributions that they've made. Priority 2 is distribution, is the first level of distribution to communities in terms of the compensation. 39% would be equally distributed. 10% would be set aside for collective purposes, and Justice Laforme spoke a little bit about this in his opening comments, and where he wants to receive feedback from you. And so this would be a fund that would be used by all 21 communities to pursue collective endeavors. And so whether that would be future litigation, perhaps it's about aerial spraying in the treaty territory, or some other form of litigation. It could also be used for other purposes, and Mizhinewe is looking for your feedback on that. There is actually currently no stipulations as to how it's being used, and so we're certainly looking for feedback from beneficiaries on the use of that. There would be a 1% set aside for living individual annuitants who are not members of the 21 First Nations. So these are individuals who they receive the $4 per year currently under the Robinson-Huron Treaty, but they are not a member of one of the 21 communities. And so they might be an unaffiliated beneficiary. So they would be on the Sudbury General list, but they receive $4 under the Robinson-Huron Treaty, or these are individuals who perhaps were born in Robinson-Huron Treaty First Nation and then transferred to outside of Robinson-Huron to another community and are still entitled to receive the $4 annuity. When we were meeting with elders and consulting with them about the compensation disbursement agreement, they were very clear that we weren't to leave anyone behind. And so that was the reason for this, is to make sure that no beneficiary or person who's entitled to be a beneficiary is left behind in whatever compensation or award that we receive. And so there is a 1% set aside for those individuals. And then the final priority payment, payment 3, is 25% of the funds would be distributed to First Nations proportionate to their population. So the larger communities would receive a bigger portion of that money, and the smaller communities would receive a smaller amount. And then the final 25%, similar to population, but this is based off of the number of annuitants. So there is a distinction in some of the communities between their total population and their annuitants, and Ryan will cover all of this in a lot more detail in his presentation. So next slide, I'm going to go into the actual settlement agreement itself. Here, the legal team and the LMC have been meeting regularly with the negotiators for Canada and Ontario on the settlement agreement since December 2022. And this was all on settlement privileged basis. And when I say meeting regularly, it was actually sometimes like 3 days per week, every week. We were meeting with the negotiators for Canada and Ontario to reach this agreement. And as I mentioned before, the negotiations on the go forward haven't started. So I'm going to take you through, next slide. I'll take you through some of the sections of the settlement agreement. I won't take you through every piece because a lot of it is probably not interesting and is full of a lot of legalese and covers who gives notice to who, when, and for what purpose. So I'm really going to cover the important sections of the settlement agreement that are relevant to you as beneficiaries. So I'll start off with Article 2, which is the purpose and scope of the settlement agreement. And the purpose is, there are two purposes primarily for the settlement agreement. The first is to settle the claim for past compensation and partially settle the litigation. So remember, we do have active litigation for the annuities claim. We will partially settle that litigation, so all we're doing is settling the past component. We would still have active litigation for the go forward. It's adjourned, so we're not going and being in court all the time, but we do have that claim for the go forward, because the initial claim was to cover both. And, so settling the litigation in the spirit of renewal of the Robinson-Huron Treaty and the long-standing relationship between the Robinson-Huron Treaty and Mizhinewe and the Crown. This is grounded in the Covenant Chain Alliance. Settling the past compensation is also in the spirit of Wigwek Sijigadik, which is in Anishinaabe-Moan, the principle of reconciliation, which means fixing or straightening out the relationship between the Anishinaabe and the Crown. The second purpose that's outlined in the settlement agreement is for Canada and Ontario to make a commitment to work with us to develop a framework for the go forward or future implementation of the augmentation promise, and that's in the spirit of treaty renewal. So there's not a binding process, but they do have a commitment to negotiate with us. And I'll talk a little bit about that when I reach Article 7, which is that actual part of the settlement agreement. The next slide. Continuing on Article 2, the settlement agreement was made despite the ongoing legal proceedings. So as Duke mentioned, Ontario doesn't like to lose. They did appeal the Ontario Court of Appeals decision to the Supreme Court of Canada. The Supreme Court of Canada agreed to hear their appeal. And so we made the decision to settle despite that ongoing appeal at the Supreme Court of Canada. And this is important for primarily because now that we've settled this past compensation component, it actually doesn't matter what the Supreme Court says about the past compensation, because whatever they say won't impact the settlement agreement. If the Supreme Court of Canada says all you're entitled to is $4, we'll still have the $10 billion settlement for past compensation. So it alleviated a lot of risk with the Supreme Court. However, what the Supreme Court says will have an impact on our go-forward negotiations. And so as we go through the future implementation process, we will have to be mindful of whatever the Supreme Court of Canada says as part of that appeal. So next slide, I'll go to Article 3. This is the money part of the settlement agreement. Basically, Canada and Ontario agreed to pay $10 billion to settle the past compensation component of the litigation. And that would be from 1850 until the date that there's a court order issued in accordance with Article 11 of the settlement agreement, and I'll touch on that in a little bit. The $10 billion is split equally between Canada and Ontario, so Canada will pay $5 billion and Ontario will pay $5 billion. Next slide. This is a really important article for everyone. This is about program services and tax exemption. And so the settlement agreement will not affect the ability to apply for and the ability to receive funding for programs or services of any Lake Huron First Nation or any individual. Your application for funding for programs or services will be assessed as if the settlement agreement doesn't exist. So Canada and Ontario cannot use this settlement agreement against your community or you as an individual to say, you've already received $10 billion in compensation, we're not going to, fund that new road or fund this program that's available for individuals. Individual distribution, so this is the money that would be provided to individuals, won't affect that individual's eligibility for Ontario Works or Ontario Disability Support Program, and that's as long as the regulations that exempt those programs stay in effect. Ontario has made it clear that there's no desire to change those regulations. So a per capita distribution won't impact anyone's ability to receive Ontario Works or Ontario Disability Support Program. And finally, Canada agrees that the past compensation meets the criteria to qualify for income tax exemption. And so that would be any per capita distribution would not count as income and would be exempt under the Income Tax Act. Next slide. No, not showing up on the screen yet, but this is the future implementation. So the settlement agreement, as I've said a few times, the settlement agreement doesn't address the future implementation of the augmentation promise, but all of the parties will continue discussion in the spirit of treaty renewal to co-develop a framework to address the implementation of the augmentation promise going forward. RHT, Canada, and Ontario agree the go-forward implementation agreement will recognize the continuing relationship to and stewardship of the land of the Robinson-Huron Treaty Anishinaabe, as well as the public interests related to the treaty territory. And finally, that implementation agreement will include a dispute resolution process to address any disputes that arise in relation to the implementation agreement. So I think, and Duke mentioned this in his presentation, from the get-go we don't want to be in court. That's not the place for nation-to-nation relationships to be adjudicated. And so the direction that we've received from leadership is to create a process where we don't have to go back to court. So if we're able to negotiate that, that would be the ideal. Of course, if Canada and Ontario, we can't reach an agreement on the go-forward implementation, like I mentioned before, we still do have that active litigation, and we're not afraid to go back. We're not afraid to go back to court. We're not afraid to fight them if we have to, and so we are prepared to do that. And this is particularly important because Canada and Ontario don't have an agreement as to how they're going to split the liability between them for the future. They agreed to share the liability on the past, 50-50. They don't have an agreement on the future. And so it's very possible that they end up just bickering between the two of them, and we're not going to wait forever for them to come to an agreement between the two of them. If we have to, we'll bring them back to court. So moving on to Article 8. Next slide. Oh yeah, no, that's the right one. So the approval of the settlement agreement, there's a few different components to the approval process. The first is having these information sessions with beneficiaries and sharing the details about the settlement agreement, about the trust indenture, and about the compensation disbursement agreement, and that's being done by Justice Laforme as Mizhinewe. And so that process needs to be completed before we can move on to our next step in the approval process. And that next step, as I mentioned earlier, will follow the trust indenture. And so we will have a meeting of the trustees, and the trustees will vote whether to accept or not the settlement agreement. Next slide. So these are the conditions that must be met, and I talked a little bit about this. We need to approve it in accordance with Article 8, which I just talked about. We have to deliver a pile of documentation to Ontario and Canada, just certifying that we've met all of these steps that we said that we would meet. And so we have to do that. And then Canada and Ontario have to meet their own internal approval processes. So before we were saying that the goal would be to execute the settlement agreement on September 9th. We've just received notice from Canada that they still haven't completed their internal approval process, so we're not going to be able to execute on September 9th. So we do have to, everyone has to meet their own approval process, and I'll talk a little bit more in the timeline about what we can now expect in terms of executing the settlement agreement. Next slide. Executing would just be done in this particular order, so the trustees and the representative plaintiffs would sign first, then Ontario's Minister of Indigenous Affairs would sign, and then finally Canada's Suriname Minister would sign the settlement agreement. Next slide. Article 11. This is partial judgment for the past compensation. And so, I think I've said it a few times, we do have the active litigation. In order to realize the settlement agreement for past compensation, we do have to go back to court and get an order from Chief Justice Morowitz, who is now presiding over this portion of our case, to discontinue the past compensation. So we'll go to the court, we'll get a court order saying the past compensation claim is dismissed because you've received your settlement and everyone's agreed to it. We would do this partial judgment after the settlement agreement is signed. So the court, we're not going to go back to court to discontinue a part of our claim until after the settlement agreement is actually executed. Next slide. And this is my last slide that I have on the settlement agreement itself. And I apologize, I think part of my slide is cut off at the bottom, but this is Article 15, which is also really important for communities, and that's the settlement agreement will have no impact on other claims, Aboriginal or treaty rights. So a lot of communities have other claims regarding the Robinson-Huron Treaty, whether they be boundary claims, some may have, all 21 communities have other grievances with Canada and Ontario, and so this settlement agreement will have no impact, or won't impact their ability to bring those other claims. And the last piece on this no impact is the settlement agreement itself does not modify or amend the treaty. It is not a treaty itself. This is just compensation to settle litigation. It doesn't define or purport to define, modify, or amend the boundary of the Robinson-Huron Treaty. So those are some key points that are important. Next slide, and this is my last slide, is a timeline for settlement. And so we initialed the settlement agreement on June the 16th. On the next day, Saturday, June the 17th, is when we had our public announcement in Sudbury at Laurentian University. We've been engaging in community information sessions since June 26th was the first session, and we're now on our 19th session, actually, because we had to do a double feature in Wikwemakong. So we're now on our 19th session. We're scheduled to be completed on Saturday, and that will be 22 sessions in total. We will finalize the settlement agreement itself and the approval process. And then on September 9th, we would have ceremony in Sault Ste. Marie, Bawating, with Ministers Ananda Singari from Canada and Minister Rickford from Ontario. And this is part of the annual treaty gathering, which is taking place on the 7th, 8th, and 9th, and all beneficiaries are invited to attend that event. The parties would execute the settlement agreement, and this is likely to happen in the fall of this year, and that's just dependent on when Canada completes its appropriations process. So before Canada can actually sign the settlement agreement, they need to appropriate the funds, and so that just, there's a process involved in that, and we can't really get around it. So they need to complete that process before they can sign. So we anticipate being able to sign in the fall, but it's possible that it could go into early 2024. The payment to the Robinson Huron Treaty Litigation Fund would happen 60 days after the court dismissal of the past compensation piece. So we imagine that will be in early 2024, January or February. Priority payments 1 and 2, which I talked about briefly and Ryan will cover in much more detail, would happen shortly after the funds are initially received by the Robinson Huron Treaty Litigation Fund. So we would anticipate that being February to April 2024. And that's just money going from the trust, Robinson Huron Treaty Litigation Fund, to your community. Mizhinewe will prepare its reports, particularly report on beneficiaries and annuitants, as well as all of the other reports that Mizhinewe is doing in December to March, December of this year to March 2024. And then the final priority payment could take up to 2 years to distribute, and that's just because of the complications associated with the annuitant issue. And then finally, the last item on the timeline is per capita payments. These would be determined by your First Nation. So all distributions to individuals will be determined at your community level, and the timeline for that will be determined by your community. But we would have a goal for mid-2024. So in the midway point of next year, individuals should be able to receive a per capita distribution. But like I said, this would be determined by your community. So that's my presentation, and I will turn it over to Ryan. Oh, Duke has one more.
Thanks, Daniel. Miigwech. So I'm gonna take a short 5-minute break to fix the projector. All right, so we're gonna start up again and continue the presentation. And then we'll go into a round of questions. And we do have the breakout sessions that are set up here for everyone to help with the work. So we're going to go directly into inviting Ryan McLeod to make a presentation on the actual financials and calculation variables of the compensation disbursement agreement. So, Ryan, can you hear me?
Good evening.
Okay, hold on. I'm going to turn you up here. Okay, Ryan?
Good evening.
Almost.
Hopefully it's better.
Okay, we can hear you now. Can't see you, but I can hear you.
That's great. I'm trying to get the video on. They had turned everyone off here, so hopefully you can see me now.
No, we got your presentation up there, yeah.
That's a better thing to see than me, so that's great.
Okay. Oh, there you are. You're up on top of the screen there, yeah.
All right. Well, good evening, and thank you for having me this evening virtually in your community of Dokis. Very happy to be here to talk about the compensation disbursement agreement with the community. My name is Ryan McLeod. and I am currently supporting the Litigation Management Committee as well as the Mizhinewe's office as we work through and move closer to a final settlement and disbursement of funds. So on my day job, I am the Chief Financial Officer for Batchewana First Nation, and formerly in the same role for Iskimuk Anishinaabeg for just shy of 3 years. So very happy to be here to support this process. So as we move through the slide deck, there is a lot of information to cover. This slide deck will be available to the community, as mentioned, through the community portal in the near future. So if you can't see all of the information, just know that you will get a copy in the near future. So overall, as mentioned, it is a global settlement of $10 billion, but it's not formally agreed to as of yet. And we are hopeful that will be completed, as mentioned by Daniel, later here in the fall. There are a number of calculations that need to be made before the funds actually flow out to the communities. And those factors include confirming population, the number of annuitants, as well as finalizing the costs. The compensation disbursement agreement was approved collectively, as you heard, by all 21 communities, and it was created back in 2012. The compensation disbursement agreement is really the way the funds will flow from the litigation fund to each community. And it was built on 3 priority areas, which we're going to cover in detail this evening. This was the original compensation disbursement agreement that was signed. You can see the flow chart that Daniel presented, as well as the text that accompanied it. So you will have a copy of this very shortly. Priority number 1 is the first payments that will be made out of the settlement. Priority 1 is really settling up with the costs as well as contributions made by each community since before the trust was established and once it was in operation, as well as any interest that has been earned by each community. So you can see here for Dokis, before the trust was established, the community contributed $50,000. Since the trust has been established, $880,100, and it's entitled to interest payable of $232,525. So $1.162625 million will be coming back to the community as part of the cost settlement portion, which again, all the costs will come off the top of the settlement, and then we'll be able to disperse funds down to the community level. All communities have contributed to the litigation and the process. In some instances, some communities contributed through the Bank of Montreal Loan Guarantee Program, as they provided a line of credit as well to support this litigation. So as we move through and pay bank fees, legal fees, the remaining bank loan, and any other costs, as well as return all of these funds to the community, once that is completed, we'll be in a strong position to start transferring funds out through Priority 2 and Priority 3. Priority 2 is around equal distribution. So after the costs are paid, a 50% will be divided, 39% paid out to all 21 communities equally. So 39% will be divided by the 21. As you heard earlier, 1% will be held for living individual annuitants. So anyone that collects the annuity currently, but is a member of another First Nation outside of the 21, they will be able to make a claim for the per capita distribution out of this pot of funds. And then 10% will be held in a set aside for collective purpose, which the Mizhinewe's office will have this question this evening within the community groups and ask for your feedback on how these funds could be used as we move forward as a collective with the 21 communities. After Priority 2 is paid, we can then make our way to Priority 3, which is a little bit more of a challenging area around population and number of annuitants. 50% of the remaining funds are divided into two categories, 25% based on population, which across the territory, based on Indigenous Services Canada data in June, which we recognize isn't overly accurate, was 39,476 members. And if we look at the 25% annuitant category, you can see there's a difference showing at 33,301 members. A lot of our work will be focused over the next several months around these two categories, population and annuitants, and we'll be directly working with your community's membership clerk or team to verify your current population as well as verifying annuitants. There's approximately 6,175 members through the territory that by Indigenous Services Canada are not recognized as annuitants. This is a very challenging area for us, as we know there are many members that were forced out of the Robertson-Huron Treaty, not by their choice, but by the government or by certain conditions placed on them. And the Mizhinewe's office will be making recommendations on how to best address these gaps that we need to be able to finalize the numbers in regards to population and annuitants. So as mentioned, this is a very challenging area, and that's why you, on the last slide from Daniel, when you see the timeline, you can see that the priority 3 payment that going out to communities is likely going to be delayed. So again, after costs are paid under priority 1, we're then able to move to priority 2 and priority 3 payments. The graph depicts on the dark green is the 39% equally divided. Under priority 2, 1% held for those living annuitants that can make a claim, and the 10% collective down at the bottom. And then on the opposite side, priority 3, making up 50%, 25% based on population, and 25% based on annuitants. We recognize per capita as an important conversation amongst all 21 communities and amongst the members. And for that reason, the Litigation Management Committee, as well as the legal team, as well as some experts, are working on providing some recommendations to each community to support them through this process. At the end of the day, as mentioned, it's every community's choice on how the per capita distribution goes and how much remains for the community's collective purpose. But this information will be hopefully helpful to each community as they work through to make those decisions. We're hopeful we can share some of this information in the upcoming sessions in the fall as we get closer to finalizing numbers and being able to talk in more detail about which each community will be receiving. So as you've heard, from June 26th until now, we've been on the go with in-person community sessions. And as we move into September through November, we'll be having follow-up sessions to discuss financial information further in order to allow each community to understand the funds that will flow directly to them through the litigation fund. The process is really divided into 3 phases. Phase number 1, community engagement, sharing information, data collection, research and analysis. Phase 2, from June until early 2024, as you heard, the Mizhinewe's report will be worked on and prepared for hopefully by March 2024. We'll be working really hard throughout the fall and into the spring, verifying population and annuitant data. And as with the settlement being postponed from the signing, we likely will not see funds deposited to the litigation fund from the government until early 2024. From there, we'll be able to transfer funds for the priority 1 and priority 2 payments fairly quickly. And then, as we mentioned, we'll be working really hard to move the priority 3 payments as soon as possible once the population and annuitant data has been verified. So as you can see, there's a lot of work still ahead of us, and this is really just the very first session within your community, at least from the Mizhinewe's office and litigation management as we get closer to the formal settlement. We definitely look forward to having follow-up conversations as we move forward. So miigwech for the opportunity to present. I do apologize I couldn't be there in person. It's much more personable when you're there in person, but I am traveling with my family today home from our vacation. So miigwech and bamapi, and I wish the conversation goes very well this evening. And we'll open the floor and I'll pass it back to Duke for questions. So miigwech.
That's what you look like. So we want to open up the floor to questions. I know it's a lot of information, but we're available to answer what we can. We do have a microphone available for those questions so that everyone can hear.
Bujo, I'm wondering if the $10 billion is an amount that's already been accepted by the communities. The amount I had been given was a valuation of $65 billion, and so that went from 65 billion down to 10. I might have incorrect information there, but why is this the amount that we're settling on other than the previously mentioned 10 to 15 years of litigation? If we're looking out for the community benefit here, why are we settling for what is apparently a small amount?
So, perhaps, did you say that your valuation was 165 or 65? Okay. So, I mean, the settlement amount was based on a series of negotiations, and of course, with all negotiations, we definitely ask for more. This figure, and I'm not sure where your 65 came from, because that's not a number that we had, but the important piece is we engaged in a series of negotiations, and what was very important to leadership who authorized us to agree to the 10 billion and draft the settlement agreement itself. Of course, it's not a finalized settlement agreement, but we did draft it based on an agreement of 10 billion. Is the leadership were very concerned about the elders, and it weighed very heavily on all of them. People have waited a long time, and you did mention 15 years of litigation. People have waited a long time. We've lost a lot of elders along the way, including elders who were even witnesses for us in stage one of the hearing. We've lost some of those people who were witnesses in earlier parts of the litigation. And the leadership wanted to make sure that these individuals could be compensated instead of waiting longer. And the reality is, in terms of negotiations, like I said, we asked for more. 10 billion was all we were going to get in terms of negotiation. So if it was going to be more, we would need to litigate to have a higher figure. And a litigation timeline would take us out an additional 5 to 8 years to reach a conclusion on that, and there's no guarantee with litigation. So that's certainly a big part of why we accepted the figures that we did, and I hope that answers your question. Unless Duke had anything that he also wanted to supplement to that.
Yeah, I think that the biggest factors are the timeline and the risk of going into court, and with the Supreme Court hearing coming up, we weren't sure exactly how they were going to be ruling on it, because what Ontario is saying to the Supreme Court is that the court has no jurisdiction on making an order against it to compel them to make a payment as part of a nation-to-nation relationship. So that's their argument in court. Whether they're successful, we don't know. But it was a risk that was weighed, as well as the time factor in seeing some compensation being provided to the community members who are aging.
So the $10 billion is a final amount then?
10 billion is the amount for past compensation. But you do have to keep in mind that there is still negotiations for the actual $4 annuity that has to be completed.
Right. I'm asking the question from the perspective of we're talking about decisions need to be made in respect to our traditions and Anishinaabe laws, and we're talking. I understand that there's people that are aging. I mean, the people that originally started fighting this back in 1850 are long dead and buried. But our obligation as elders and as individuals to our communities is to look 7 generations ahead. So not current generations or past generations as well. So if we're going to look ahead, then how far ahead are we going to look, or are we going to look behind?
Well, I think the leadership is continuing to look ahead. The amount that is considered as part of this past compensation settlement, it is a significant amount of money that is going to be transferred, shared with 21 First Nation communities, and that could essentially change circumstances for every single one of those communities. It is up to us to work together to look at how it can achieve benefit for the future generations also. And that is the primary focus of Mizhinewe, to help provide some of that guidance, because I think he's going to be looking at a lot of experiences from other communities who have adopted different approaches when they achieved settlements for their own agreements right across the country. And he's going to be providing what he feels are some of the best practices that were used by communities, as well as some of the pitfalls of some other practices that were used. So those will be all taken into consideration. So all of those will help inform what the best decision that each community is going to make on how these funds would be used by each community. The trust itself doesn't have any form of decision making in that way. We can only provide the payment of the share of the 10 billion for each community, and the report that Mizhinewe is completing will help in those community discussions to create whatever plan is going to be created. So I think there's a whole number of considerations that leadership had to look at, and they looked at it from a risk point of view. I would say, is it an appropriate amount? It's subject to everyone's opinion, but we're not aware of things that are out of our control. One of them being the court. The other is the nature of the political system in this country. We don't know whether or not there could be an election on the federal side. There could be an election on the provincial side even. And we don't know whether or not there'd be a willing participant to sit at the negotiating table. So there's a whole number of variables that were weighed against accepting this agreement. And the $10 billion figure is what is being proposed. What I will say about the future is that I know there's very strong opinions that collectively we have to put our minds together to ensure that there's appropriate accounting for every single revenue that is being generated from the territory, because that hasn't taken place at all, and it's just actually started just as of recently because of our request for information on what that accounting is, as well as a requirement of the courts in the Stage 3 proceedings that we're going to start. There were submissions that indicated that Ontario itself had valued this claim at $1 billion. So that's what they were putting forward in the court. So there's a whole number of things, and the $10 billion figure is as fair as we think we could have gotten it. And as Daniel had said, there was a request for more. Leadership authorized to seek out more, and right up until the last, prior to accepting the $10 billion figure, the amount was a lot lower than that. I hope that helps. Miigwech for that question. Next.
I'm just wondering if we could clarify the 25% and the 25%, how that's going to work out. Like, how is that? What's the big picture? How does that look?
Oh, nice one. Nice question. So the difference with that that part is during treaty times, there was many of our people were going back and forth from the mainland to Manitoulin. And a lot of them were actually living on Manitoulin. And so the beneficiaries or annuitants are spread out throughout the territory, including the Manitoulin First Nations. In my community in particular, because I can speak to it, I'm from there, I know very specific instances where there are siblings, both with the same parents. They're 1 year apart. One of them receives the $4 annuity, the other one does not. So that's where the discrepancy between the membership and the annuity figure, that's part of it. There's other instances where the Indian Act itself it's racist, and it was racist and discriminatory. When women got married, they lost their benefit status. There was a policy in place by the federal government itself, the Crown government, where they chose to make it policy that children could not gain annuity status from their parents for a period of time from 1898 to 1917. So there's a whole, like a couple generations of people who weren't able to get the benefit of an annuity. So all those have to get taken into account and reconciled. So when Ryan's talking about work needs to happen in finalizing those calculations for that 50 or that final 25% amount, that's the type of work that needs to happen.
Between annuitant and member, between annuity or the people that get the annuity and the population. Population, does that mean that they live on reserve? Or
No.
Population everywhere that's native but not getting the annuity?
The figures that are being used right now for presentation purposes are Indian, what's it called now? It was called INAC, Indigenous Services Canada, and the Indian Registry System. So these are population figures that Canada has for each of our communities. But it does get complicated even more because some communities have their own membership codes. So some of them, they're not accounted for in the actual membership or the population figures either. They might be an annuitant, they're eligible to get it because ISC controls that list still. So they might be able to get it, but they're not considered part of the community.
Okay, so how is that going to work all together? Become part of the community or do they not?
Oh, good. Gimmo. Miigwech.
So I'll just speak on behalf of Dokis. So it's roughly estimated at this time, not to the exact date, there's 1,400 members in Dokis and we're 1,400 annuitants. So it doesn't matter here at home because we don't have a membership code that will dictate if you're on the Indigenous Services Canada's list or off, or we don't have members that are not beneficiaries. So in our case, it's not a worry, but you will see though that on 25%, because there's some are not annuitants, it might be increased. So in some instance, there's one nation that, because they have a membership code, Indian Affairs might have a list, but they're less as band members or citizens or that. So for us, it's not actually a concern here. If we're 1,400 members, we're 1,400 annuitants. But you might see an increase, and that's because we're benefiting from, unfortunately, other nations. So I hope that clarifies it, because I had to ask that question too, because 25% is 25%, and we had a different number. So.
And part of, I think Ryan did say it, is that he's hesitant to share actual numbers of what is going to each community because of the fluctuation of that number. So until it's finalized, I'm sure Gima is going to be the first one to tell you what the number that's coming to Dokis is.
Ani, everyone, thank you so much for coming out. And I want to say chimigwech to all of you for all the work that you've done on our behalf. It's unreal what's coming out of this. And I want to say a really, really big thank you to Michel. We knew him as Michel when we were growing up, Mike Restoul. So yes, he is originally from Dokis. He's a Nipissing band member, but a big heartfelt thank you, Michel, for all the work that you've done. So just a couple of questions. Is it being signed on September 9th, the agreement?
The First Nations are meeting at the end of the month, so they'll be asked whether or not they're going to be authorizing their trustee to sign the agreement on behalf of each of the 21 First Nations. So each council will be authorizing a trustee to sign. Ontario, they're prepared to sign. They've already gone through their budgeting process. They've allocated the funds. It's already in their Indigenous Affairs Ontario Department account. So it's already there, ready to go upon signing of the actual agreement. And Canada, they still have to go through their appropriations committee, and they cannot get that done until the House of Commons begins sitting again. So what is being planned for September the 9th is still a ceremony, pipe ceremony, and the ministers are going to be there. They've confirmed that they'll be there on Saturday, September the 9th for that ceremony. So in my view, I have to get this confirmed with the rest of the trustees and the chiefs and the councils, but that would effectively determine that the agreement is agreed to, or the amount is agreed to, and subject to a technical aspect of Canada finally signing. But they've committed publicly that this is a signed agreement.
Okay. So, having said that, I'm not clear on the report that you're going to be doing. Is the report based on the 10% to the 21 First Nations, or is it a report on distribution, or has that already been the distribution to the First Nations and that's already been developed in the distribution agreement, correct?
No, there's going to be recommendations from Mizhinewe on use and application, best practices, how to manage it, as well as his own personal recommendation based on what he's heard. And as part of this process for Mizhinewe is he brought on Ryan McLeod to help with developing calculations and variables, models that would be considered by each First Nation. So to your question about has a decision been made for what that balance is? No, there hasn't been. the decision lies with the chief, the council, and the community.
No, I mean overall. Like, so there's going to be a report. There's going to be a report, right? You're going to have it done possibly by December. What is that report?
What is it?
Yes.
It's effectively going to be, as Duke says, it's going to talk about the overall compensation, how it should, I'm going to get from you, how it should be dispersed, what's the best practices. Like, for example, if you're saying, if somebody's saying, well, we want 100% disbursement, I'm going to be making a recommendation that talks about that issue, and I'm going to be, whatever I come up with, or whatever my recommendation, it's going to be based upon my findings of who I've, what the results were of other communities that have done 100%. It's not good right now, but I can tell you that'll be part of it. It'll be part of, it'll be suggesting, I'm going to be doing something that goes from the time the First Nations get their distribution, all their funds, and then I'm going to be talking about going forward and how best practices, how you should do it. For example, I might suggest 50-50 split of all the money. You know, some goes to community improvements and all the economic developments. The reason I say that is because I've had experience with that. My own First Nation, for example, does that. They gave the community members a certain amount and some every year. That's how they do it. And meanwhile, the big bulk of that settlement is in a trust and gets invested. And in the meantime, while it's getting invested, it serves the community purposes of roads, education, business development, all of that. So that's the kind of thing I'm going to be looking at.
Okay, that's a good example. And bear with me, guys. I just have a couple more questions.
Okay,
so,
Mizhinewe?
there was a discussion about all the 21 First Nations not going to affect programs and services. You can apply for money, you can do all that. But will this money, it won't be used or recognized as own source revenue? Okay, for sure. Okay, perfect. I'm going backwards here now. So, and my last comment, two things I wanted to mention. So it was mentioned in your presentation that it was a collective. The treaty, it was between the Crown and the First Nations, and it was to the collective.
Right.
But it went to the individual in 1855, and there was a number of factors. Could you explain what those factors were, why it went to the individual?
Why it went to the individuals?
From the Crown?
My guess is because it was cheaper. It was easier to do it that way and not care about the amount, and they didn't have to, they weren't augmenting the original annuity of 600 pounds. 10 years of augmentation of that should have, I don't know what it should have been, but at least halfway through 173 years, it should have been $5 billion at least.
Oh, for sure.
Yeah.
But there's a little bit more history to it than that.
You have something?
Yeah, so part of, or one of those key factors is actually just the government's colonial machine and removing authority from your own governance structures. That was a key factor in the government superimposing themselves in the place of your leadership. And, you know, we will just give individuals payment ourselves because, well, we're taking charge and taking over the governance structures of First Nation communities. So that was a key factor in terms of the government's policy to take over distribution to individuals.
Okay, but there was also just, so, you know, we talk about collective and we talk about individual. The Indian Act has been in operation long before 1855. So the Indian Act took away collectiveness and made us numbers and made us individuals. To this day, we're individuals. So we're talking about collective. That's why you hear a lot of stuff on Facebook and stuff like that. You know, I want mine, I want mine, I want mine. That's hundreds of years of drilled into us now. So when Canada took over, it was also because there was nepotism when it came to passing along to the First Nations, to the tribes, and not everybody got their fair share. That's one of the factors that probably needs to be addressed as well, that why Canada stepped in. Instead of fixing the problem, they just became the great white father and decided to take over and lead us. We don't need that anymore. And that's all I have. That's all my questions. Thank you for listening, and thank you so much. Your presentation cleared up so much for me. Thank you very much.
So just one point and why we appreciate it, because we're going to be creating our own ways of distributing the funds, and which is great because nothing has been decided. This is our first meeting. What we asked at the Chiefs meeting is that how can we get something as a framework? What can give us examples? What can give us areas of what people can rely on or make use of, or best practices out there? So that's the process of the report. And speaking with Mr. Laforme too, is that it's still up to the community to accept those recommendations or not, or change. So it's not that the recommendation is, oh yes, this is what it is. It's going out again to the community. So after this meeting, this is what we want to schedule, more meetings like this to bring this out. It's not Chief and Council deciding, it's the community saying this is what we want. So that's what just a reassurance that at our sessions we all said that we don't know because we don't know yet. And that's the hardest part of this whole process. Is some band meetings we go, well, this was phase 1. What happened? I can't tell you. This is what happened phase 2. What happened? I can't tell you. We won because of the protection and the litigation part of it, that you can't release information. So hopefully now that it's out there, we can sit down after today's session and we start really brainstorming, because you see the dates. It's not tomorrow we're getting the money. So it's not something that we rush. And that's why we want to make sure that everybody's included. And it means so much for us to say, okay, so let's sit down, let's have sessions, whether it's here, Sudbury, Toronto, wherever everyone is, to make sure that your opinion counts. Because it's not us that's going to decide, it's the community. So that's our reassurance that we enjoy that, because there's things that maybe other communities out of the 21 were one. There might be 20 other suggestions to say, oh, never thought of that. That's a great idea. Things like pension plans, healthcare, Christmas bonuses. So there's all kinds of things that can come out of it that is best for everyone. And it also takes away that you're living on the nation or you're living off. And we always have that, and we want to eliminate that to make sure that it's fair for all our members. So this is why the report is going to be great. We can appreciate it. We can go through it. There's things we can say yeah, and there are things we'll say no, because this is what Dokis wants. So just to make sure that we have not started anything. So this is the first start, and all your input is valid. So.
So in other words, where's the money, but we don't know how much we're going to get in it.
Yeah.
I came to the meeting and I found out nothing. And now there's going to be an appointment there in September 9th, but they're not all going to be there. Because the recession, what do you call that, when the people get back together, hasn't been done yet. Exactly?
That's very good, Brian. And I have to, I guess, comment on the work of Dean and Duke, because I think historically it was the first really time that a conservative provincial government and a federal liberal government were actually sitting down with us and getting along in somewhat. But they actually listened. And then everything came about and the shuffle came out. So we lost Minister Miller. And I think for us, I haven't met them. I know we were in Sagamok that day when the shuffle happened, and Duke was in the back, and he said to us, if you see me leave, it's just because the announcement came. Who's the new minister? And I think they took it upon themselves to say, right now, at this hour you've been appointed, we're going to talk, because we can't let this go. And I think it's due to the fact that how much they care. They're saying, this is not you can't let this go. And why we can't talk about numbers, unfortunately, from now to the effective date, some people are being deceased and other people will be born. So it's really hard to get at a stake number, because it's 10%, 1%, 39, 25, 25. So I think in the near future they might have roundabout, maybe estimated numbers. Hopefully nobody passes away. Maybe more people will be born. Then we can get that number. But that's something that, because it's a huge fluctuation, if throughout the 21 nations, if people are passed, it does change. But further to see what the distribution is or what the amount are, that will be our decision from it. So